All right. It's recording. Let me stop the transcription here. All right, you are recording.
All right. Good morning, everyone. I want to thank everyone for being here for the Law Enforcement Subcommittee, the task force on the cannabis derived intoxicants and illegal cannabis production. So what we're scheduled to do today on the agenda is really take a draft. It's the fourth draft version and kind of go through it. Rob Ovett has been so gracious in putting this together with assistance. I know there's been some additional comments that have been coming into him, which is very good. I know that Rob prefers to have people come forward with stuff while he's working on it instead of bring it in toward the end. So this is an opportunity for the subcommittee to be going through the draft. I know that there's also a number of individuals that are guests today that are not part of the subcommittee. I just want to make certain you understand that we will in fact have public comment on this. But at this point, we're just really putting the draft together so it can be presented to the full work group task force as we move forward. And that's definitely when we will be taking public comment, if not at other times besides that. What I will say for those who are guests, if you do in fact have comments that you would like to get on the record, I shouldn't say on the record, but before us as a subcommittee, feel free to submit those to our council. And that is a process that will ensure that we have captured those and they can actually then forward it to members within the
everything.
All right, someone needs to mute, please. And then that will allow us to have some type of understanding and control over what's coming in and making sure we have an accountability for that. And then, like I said, there will be the formal presentation and public input time for anyone that's on this call now and others who may join us at that time in the future. So with that, I'm going to go ahead and ask for Tisha, if you'll, or Michael, whoever's going to do the roll call, if you'll do that first, and then we'll, since I've already done the meeting overview, we'll move right in from there to the discussion on the draft.
Great. Senator Przanski.
Here by video.
Rep. Morgan.
Present by video.
Sergeant Bechtel. No, he was on the phone. It's just
We'll come back to Sergeant. I believe he was going to transition to video.
Yeah, okay. Josh Eastman. Josh, you're muted. You're still muted.
There we go.
Here by video if it didn't work the second time.
Perfect, thank you. Heidi Ferguson.
Here by video.
And we also have Aaron Pettigrew here from the Oregon Judicial Department. Hi, Aaron. And Justin Dillon here in place for Jake Johnstone.
Yes, here by video.
Aaron Seiler.
Good morning, here by video.
Morning, Aaron. Kurt Miller.
Present by video.
Courtney Moran. Courtney Moran. No. Sheriff Zickler.
Present by video.
Amanda Swanson. Scott Winkles.
Good morning, Scott Winkles present by video.
Good morning. That's it. Thank you.
All right. Well, thanks everyone for being here. So at this point, we are going to move into the review that we have on our draft 4. Rob, since you're the author and architect in putting this together, I'm going to let you be the MC today and kind of walk us through And I'm not sure how you want to do it. If you want to do, I'm suggesting that we do section by section, getting comment at that point so we can have maybe a little bit more uniformity. Do you want to have any general comments at this point? I mean, I think you should start off and then we'll work from there.
Thank you, Chair Przanski. Yeah, basically the fourth draft that got sent out to everyone last week is just growing on the previous drafts that we had talked about. So there's really 4 parts to the draft. Sections 1 and 2, we've kind of already talked about. That's the search warrant statute cleanup. There's no change. I didn't make any changes to those sections. So we can restart that conversation if you want, but I think we had pretty much settled all that out. Sections 3 to 5 are the law enforcement tools that we also talked about, I think, at our last 2 meetings. That's the trackers, wires, and pings that the sergeant was talking about, and 2 of which were actually scheduled to get cleaned up before the 2020 legislative session collapsed. So the new stuff is really all from sections 6 to 15. And there are 2 components in there that are new. Section 6 to 9 is essentially the enhanced penalties that the sheriff has been talking about for a while for high amount possession and manufacture and or in conjunction with any of these other bad acts that are being found fairly regularly, such as labor trafficking and environmental crimes. And so I went about that by way of adjusting our commercial drug offense statute in the marijuana code and adding those elements to it. You can see those through section 6 and 9. I'll talk about those sections here in a minute in detail. And then the second new kind of bulk sections would be sections 10 to 15. That's the cleanup, financial liability, potential lawsuits, and leaning for cleanup. And I borrowed really heavily from what we talked about last time, which is our meth lab cleanup statutes. Now, those have different environmental problems, and so I was able to make these sections much shorter because meth labs produce some toxicity that beyond just the environmental damage, there's like cleanup to make it even safe to be there physically present. So it's not as detailed. It's pretty straightforward, I think, in terms of the way I constructed 10 to 15, because it does mirror what's in existing ORS Chapter 475 related to illegal drug lab cleanup. So that was the basic scheme that we talked about. I crafted it all, but as you may remember, I'm hoping you remember, Chair Przanski, I gave everybody the warning that probably you're not going to like this draft. So it is just truly a working draft. So if anybody gets real ramped up about any of the details, that's fine. Let's work through it all and talk through it all, because it is just an initial draft. But let me kind of explain at least those sections that are kind of new. I'll just do a section by section brief summary so you can see what's kind of going on. Yeah, go ahead.
Yeah, before we start in with the new, I just want to just let's do a check-in with everyone. As you've heard, 2 things. First of all, Rob captured exactly what I would be telling everyone. This is a rough draft. He has put this together at my request, and you know, his vision may not be other people's subcommittee members' vision. This is the time for us to have those conversations so we can, in fact, see where we have a meeting of the minds and where we don't. And the other part to this is I think it's worth just doing, let's say, call it our final check-in. But sections 1 through 5, as Rob says, we've pretty well gone through these more than once in most cases. It seems to me that we've got check-in and check-off on those sections. But let's just ask for subcommittee members if you have any other reservations or points that you want to make, positive or negative, on sections 1 through 5. Let's do that first so we can kind of put that just aside and we can move forward and really focus on the new stuff. And then going forward, we can really limit our discussions and reviews on the new stuff as we may want to be amending it. So with that, colleagues, are there any comments on sections 1 through 5, or are we ready to move into the new stuff, sections 6 through 15? Aaron? You're muted right this second. You're still muted, even though it doesn't look like you're muted. I'm
Star
not
six,
hearing you.
maybe?
Oh, yeah. Yeah, try *6. Well, you're on video though, so that shouldn't be an issue.
Aaron,
Looks
is
like
your,
Judicial hasn't paid their bills to get their audio up.
Aaron, is your computer volume on?
I noticed when it was attendance that we didn't actually hear your voice when you said you were here either. We saw your lips move but didn't hear you, so.
So, Aaron, I think it may be best for you to sign off and come back in. There you go. Got it. See it. So while she's doing that, is there anyone else that has any comments on 1 through 5?
This is Courtney Moran. I'm good with 1 through 5. I just wanted to let you all know that I'm here for attendance.
All right, thank you. All right, we'll give it another 30 seconds. If not, Rob will start the preview and then we can always come back. Here she comes. Hi, Aaron. Sorry, we are not hearing you. So what we're going to do is we're going to put you in the reserve category. You made it a marker here. We know that you have some comments on 1 through 5. With bated breath, we will wait and hear those when we can hear you. But we're going to go ahead and move forward into the new section. So Rob, when you're ready, section 6 through 9, I think is the first one that you wanted to go through, or just ID for the record where we're at so we can have a calling card for those who are tracking this at another time.
Sounds good. Thank you, Chair Przanski. Okay, so the new stuff begins really on page 9 of the draft, fourth draft, with section 6. Section 6 and section 7 are basically mirrors of each other. This deals with possession of marijuana, and what it does is it basically creates a higher level crime that you'll see on lines 10 through 19 on page 10. And it creates it both for the super possession, or for lack of a better term, whatever number. I just plugged in 32 times the maximum amount allowed under Measure 91, but maybe you want to go a different number. I don't know. That will be the super possession that we talked about. And then paragraph B, which is lines 13 through 19, create an alternate way to get to that enhanced crime based upon committing labor trafficking, OSHA violations, environmental endangerment crimes, and water pollution or theft of water. So that creates that enhancement to get you there based on what the sheriff has been describing for, well, a couple years now. So that's the basic structure of how I would recraft the enhanced possession offenses, and that's true for section 6 and section 7. Section 8 is the enhanced manufacture. It basically mirrors it in the same fashion, but it focuses on more on plants rather than by volume of possession. And again, I just pulled out a random number, 100. We talked about that being a federal threshold, and so I was trying to mirror that, but maybe there's a different number, maybe there's a different approach. And it has all the same enhancements that I talked about previously in sections 6 and 7. And then where that all matters as a practical matter is in section 9. Section 9 is the commercial drug offense statute that I previously talked about. It applies only to cannabis at present because it got pulled out of the Controlled Substances Act, so it's unique to just marijuana. I have been talking with various practitioners about adjusting these statutes anyways. I think Lee mentioned to the chair the other day, and then we've been continuing to talk about this statute for some years. But this is the statute I chose to open up, so to speak, and it would essentially create, if you go to the bottom, lines 27 to 29, it would create a crime category 8 for those enhanced crimes. And that's how it would essentially work. The things we've been talking about amending, just for what it's worth, are higher up in the statute, but that's a separate issue, and we can talk more about that. So that's my summary of sections 6 through 9, which are the criminal enhancements that we've been talking about. So I don't know, Chair Przonski, if you want to open that up for conversation, or if you want me to explain 10 through 15, because that's a whole different topic. That's more about cleanup and responsibility.
No, I think this is a great break point, and we'll just keep it in this kind of category. And what I took from your presentation is that in sections 6 and 7, they're basically dealing in the same general areas as to how you framed it. So I'm just going to open it up for comments. Lily, I see you got your hand up, but let me just make this statement before. Let's go ahead and just, instead of bouncing around 6 to 9, let's just kind of go through, and we'll start with 6, but of course, comments that would be applicable to an adjacent section such as 7 are free game as well. So we can kind of just have a coordinated effort for those who are going to be capturing this at another time. So Representative Morgan, go ahead and go first, and then we have 2 or 3 others in line.
Thank you, Senator. I appreciate this draft, Rob. I guess I just have a question. I recently, Sheriff Sickler and I were at a presentation where we heard the solid waste employee in Josephine County report that people using a local swim hole in my district have been receiving chemical burns while swimming from the runoff of cannabis grows up the hill that are illicit. And I see that environmental impact is on here and theft of water. This is a situation where they're using illegal pesticides and other chemicals to grow the plants, and it's getting into the waterways and running down the hill into our river, and people are literally getting burned. Is that covered in this, or would it still need to be something else?
I'd have to look at the statute again, which I'm in the process of doing, but I actually did include the environmental crime statutes, 468-951, as well as 468-943 and 946. I'm guessing that probably both of those are covered, or your example is covered in 4, but I need to actually look at the statute to verify that real quick.
And Chair, I can probably address that in my comments when you get to my side of it as well.
Okay, Kurt. So let's go ahead and go with Sheriff Stickler, and then I'm going to need some help to see who else is here. I know there's 2 or 3 that popped up, and I'm only seeing certain individuals at a time. Sheriff?
Hey, thank you. I was curious. So Class C felony, and maybe Mr. Eastman could explain what that would mean as far as any type of, I guess, accountability within the criminal justice system versus, I think we originally might have started with a B and then moved it to a C, maybe at some after some comments. But anyways, Mr. Eastman, could you explain the matrix, the sentencing matrix, and what a C felony might be versus what the current drug law is real quick?
So with the super possessions being Bs, that just means that there's a 10-year maximum, but the level 8 and the criminal history still control. So it's the same. It's just that if somebody were an 8A and it's presumptive 41 to 45, we would still have the time in a B felony to have post-prison for the legislatively 3 years versus the 15 months before you hit the statutory maximum. And then on the back end, I think it's 7 years to set aside a B felony versus 5 years for a C. But in practice, the grid controls non-mandatory sentences. So making it a B just gives us more room for that. We don't run into that 60 cap as quickly, but most of them we don't, in my experience. But it's still an 8, so it's presumptive prison regardless of history, and then it's just longer to set aside on their record, etc.
Okay, thank you.
All right. Let's see. Kurt, I think you may be next. Let's go ahead and go with you, and then we'll see if I've missed anyone.
Thank you, Senator Brzezinski. Hey, I just wanted to first touch on the questions that Rep. Morgan had, which is kind of was the main thrust of my comments as well. I very much appreciate Rob's work on this. He's a champion of drafting these things, and he always puts together a pretty good product for us to start with. I've been speaking with our environmental crimes prosecutors, and I think that's probably the area that we need the biggest focus on. The ones that Rob began to highlight are the most serious offenses that are contained in there. That's actually a B felony, environmental endangerment, that is punishable by 15 years in prison, which involves serious physical injury or the risk of. So honestly, it's not something we have seen. It's like the unicorn of environmental crimes. And I know Rob knows that as well too. So what our environmental crimes prosecutor and I have been discussing, we think that there'd be a little bit better mechanism for enforcement from the environmental and water rights. We need to specifically reference the pesticides, as Rep. Morgan mentioned. And I think that our team is going to be able to put together some recommendations on this for hopefully next week is our goal. And what we were thinking about doing was rather than citing the specific crime itself, that we'll focus on some elements of the crimes that are most important as factors, so that if those factors are present with the other marijuana offenses, then that would be something that would elevate it. And maybe we can even find some of the less serious factors and turn that C felony, as Sheriff Sickler is pointing out, into like a level 6. So it has a little lesser severity, but something that's more recognizing the dangers that the environmental crimes and pesticides use bring to the table on a marijuana offense, and then move up to the level B felonies with the level 8s, as Rob pointed out, which are more serious offenses. So I hope we have enough time to get that still to the drafting table the week after, and we should be able to maybe later this next week get it to you folks. I'm kind of stuck because I have a trial 3 days in Morrow County next week, and my environmental crimes folks are bouncing in and out of vacations for the next 2 weeks. But those are the main two things. If the board would like, also, I can check in with our DOJ folks on OSHA to see if we've captured the appropriate statutes there, as well as the trafficking section. You know, we have a trafficking section as well. So I get big thumbs up from Rob. So we'll kick it over to that side as well and see if we can get some better statutory references or elements to reflect really the conduct that we're talking about and trying to capture here. That's about all I have, Chair. Thank you.
Kurt, thank you very much for the input and insight and the direction you're going. Sheriff, I see you're back up.
Oh, sorry about that. I just didn't lower my hand.
Okay, that's fine. I just want to make sure. So that's the only names I see on the screen right now that had any comments on 6 through 9. Just want to make certain we've covered those points. And it's Rob, again, thank you for your efforts, because as you can see, just fine tuning's coming in at this point. Anyone else on 6 through 9? All right, Rob, your show on 10 through 15.
All right, well, 10 through 15, which is really 11 through 15, 10 is a codification, is basically, as I mentioned, designed around the cleanup process for meth lab sites. But I converted that over to essentially environmental sites as a result of, you know, these large DTO marijuana grows. So I can go walk you through each of the sections if you'd like, but really the gist of these sections is to, you know, put an owner on notice that the property has been used for this, to engage in the environmental cleanup. Ultimately, it's up to law enforcement to call in that cleanup the way it's crafted here, and then the cost of the cleanup become a lien against the property. And that's the basic design of what I've got in the draft. There's a lot of details, and I don't know if I want to go through line by line with you, but I'm happy to do so. But hopefully folks have had a chance to read it. I think it's pretty straightforward. But again, I think I was the drafter of the original 475 provision, so it all makes sense to me, but maybe it doesn't make any sense to anybody else. And so this is the one I gave my biggest disclaimer about, you may recall, Chair Brzezinski, because if any of it doesn't quite make sense to folks, I'm more than happy to explain it, but I kind of need to know what they're wondering about. But okay, that's the basic gist. The gist would be to authorize law enforcement to bring in a contractor, clean up the mess, pay the contractor, lien the property, and go from there. Now, I understand that DEQ may actually have some resources to provide law enforcement some front end funding for this. So we may need to talk about that and integrate that in somehow, because law enforcement doesn't have bank accounts ready to pay for big cleanups. So we'll have to talk about the mechanism, but the basic design of the lien process and putting people on notice and moving forward from there is the same scheme as for meth labs.
All right, let me start off with the comments. I want to make a distinction here. We're working policy for everyone, and I want to make certain that we stay focused on policy regarding revenues and streams of money. That needs to come in through another process. I do not want to see the hard work of this subcommittee waysided once it, by pushing the bill down to Ways and Means if it doesn't need to go there for the policy part. The funding part definitely is a concern as to something that needs to be addressed, but I'd like to do the best we can to keep them separate so we can set policy and then have the Ways and Means discussions for resources to be available for law enforcement to carry out these tasks. So with that comment, let me ask for other subcommittee members for your input regarding 11 through 15. All right, Rob, again, I think you're batting 1,000 now. Please don't let it go to your head, but at the same time, thank you very much.
No, I won't. And I gotta be honest, Chair Brzezinski, I think after people read it some more and more, they're gonna have questions and comments because it's a bit tricky here to make this fly right.
Yeah. So for those who are taking part in this that are guests, Rob and I have known each other for many, many years. He's been an excellent resource. So I take a little latitude with some of my comments that I make to him since out of friendship. But this is an area, I know we have a number of people here that are guests. As I said at the very beginning, this is an opportunity for you to hear what we're, as a subcommittee, are talking about. If you have comments on regarding these various sections that we're talking about, what I'm going to encourage you to do is to put them, articulate them into a text, or excuse me, into an email, send them to my judicial counsel so they can actually coordinate those and then get them to Rob and whoever else may be working with him to have an opportunity to be prepared to respond to those either through the drafting or when we have the public hearing. So we will be more informed before we get there, and it won't be kind of a last minute, oh gosh, we need to take care of this type of thing. I'd rather have those comments earlier than later. All right, back to the subcommittee. Again, understanding from what Rob says, there's a lot of detail here. So what I'm going to ask you to do is similar to what I've just said for the guests that are attending. If you don't have comment today, but you have an opportunity to review it and you have questions, I'm going to ask you to also run those through council. So again, we have some type of log, I'm going to call it, a registry as to what's being considered and on the table. So again, we have a good record and people will know how we got where we got when we get there. All right, I see two hands up. I think Courtney, I think you were up first, and then Kurt will come back to you.
Yeah, so I have a couple questions / comments. So if I can just do one at a time to get the answers from Rob. Rob, what does it mean under owner or operator when it says participating in the management? What does that phrase mean?
Okay, so you're up in the definitions in section 11.
Yeah, line, section 11, sub 3. Yes.
Yeah. So owner operator means a person who owns, leases, operates, controls an alleged manufacturing site as described in this section. Doesn't include a person who, without participating in the management, holds indicia of ownership, primarily protected security interests. So that's something I had to build into the 475 statutes when we were writing the meth lab cleanup statutes to make sure the banks didn't lose their interest and their priorities. Quite frankly, I didn't think that language was necessary, but the banks insisted upon it, and I like to keep the bankers happy because otherwise they lobby against a bill. So that was basically designed. That second clause, owner or operator, does not include a person who, without participating in the management of an alleged illegal drug manufacturing site, holds indicia of ownership primarily to protect a security interest. So that's the banks, basically.
Okay. And then kind of a broader comment or question, which goes along with this. Last time we had talked about, does somebody know, right? Or should they have known what's going on in their property versus them actually knowing? And then how do we get to forfeiture or fines, and where is that with this?
So in order to essentially strip someone of their innocent ownership defense under the forfeiture law, civil forfeiture or criminal forfeiture law, you essentially have to dispossess them of their innocence through one mechanism or another, either because they knew or should have known, or as you will see on page 15 in lines 20 through 22, if you fail to take reasonable precautions against the reasonably foreseeable acts or omissions of a third party, and then you get the consequences. So essentially putting owners on notice that, hey, if you do this again, or if you allow this again, you're kind of on notice. So I guess that was my effort to try to address that issue within these cleanup statutes, and I kind of carried that over. So I don't know if that makes sense to you, but I would point you to 1F on lines 20 through 22 of page 15.
Okay, yeah, I think that with the knowing or should have known in the notice piece, are we going to do something about forfeiture and fines, or does that does it?
Well, I was really, at least when I was crafting these sections, was really focusing on the cleanup and the liening and then the liability. I wasn't really focused on forfeiture. That would be requiring us to go into 131 and amend those statutes, but I don't think those need amending. The Constitution really constrains forfeiture, civil forfeiture under measures 3 and later 53, as I remember the numbers. Senator Brzezinski might remember better. So there's, we have some real restraints on forfeiture, but an innocent owner can be dispossessed of those innocent rights as well if people go through a ritual. But I don't know that there's any changes necessary, but I'd defer to Josh or maybe Sheriff Sickler if they're finding our civil forfeiture statutes not workable in this context. Beyond the Constitution, because we do have those limits based on measures 3 and 53.
Yeah, Josh, if you could weigh in, because I thought you had some really good ideas from our last subcommittee meeting, and I'd like to hear your thoughts.
So civil forfeiture wise, I know our county council has initiated proceedings a couple times. I don't think we've actually gone through with forfeiture all the way due to attractive nuisance, cleanup costs, everything that the county assumes, and our county is not flush with funds. But it has been a deterrent and an incentive to, I think they're dismissing forfeitures, but they're putting an easement appurtenant, or I forgot the word, that like where they won't be used for a cannabis grow going forward in exchange for allowing owners. But as far as going all the way through, I don't think we have done any. I think it's too costly for our county to proceed on that. And then my idea was more of a criminal statute with a lower mens rea, and of course would be a misdemeanor based on that lower mens rea for the owners who insulate themselves via a lease or layering, sort of, instead, because as it's currently written, to get the landowners who obviously know, everybody knows, but what I know and what I can prove are different, because aid and abet is a specific intent crime currently, so we have to show with intent to promote, facilitate, etc. Whereas what I was suggesting was a misdemeanor version of allow, so unlawfully and with criminal negligence allow property to be used or something like that. So then we could be that know or should have known standards. So the take 100,000 cash and turn the other way is not an escape from liability, basically.
Courtney, anything else?
No, that's it. Thank you, Josh. I think that's a good idea. I mean, the folks that I've talked to feel that if we can stop the access to land, that would really impede folks from, continuing these illegal grow operations. Thank you.
All right, thank you. I've got Kurt up and then Representative Morgan.
Thanks again, Senator. Appreciate that. I think my first comments really are just turning it more towards, I am not an expert on this type of area as far as drug cleanup side of it. So I just really want to recommend that like the sheriff and other law enforcement kick it over to their county council, since they're the ones who are going to be dealing with this. And I know Rob is county council, so he drafted it with that in mind, but the more set of eyes, the better. I'm going to kick it over to the DOJ side of it for state police. So Sergeant Bechtel, I'll kick it over to your folks for them to review it as well, just so that we get enough set of eyes on it that we're not missing something frightfully obvious. And I think that would help us on that end. And then from the sheriff's and law enforcement side of it, like Sergeant Bechtel, if you can just look through also for the what's the definition of waste, as Rob did a really good job of explaining it there on page 14. Maybe there's some other things that you obviously see all the time that we need to mention on there as well. And lastly, I'll kick it over to my environmental side of it as well, because I think that's another piece of it that we should address, just like what are the issues, because a lot of this is coming down to, as Rep. Morgan pointed out, like the pesticides and the chemicals that are around those particular sites. And so maybe we can kind of throw a little bit more onto that as well. But that's all I had on this side of it. So thank you all again, Rob, and thank you for some time, Senator.
All right, thank you. Representative Morgan, and then followed by Sergeant Bechtel.
I'll be quick. Thank you, Senator. Rob, I want to take it back to that financial immunity of the banks. In the current climate of drug trafficking organizations financing, you might have a private financer that is paying for the property, but still is aware of what's going on in kind of a criminal organization kind of function. They can say, I wasn't involved in the management of the grow, I just paid for the property. We had some local, I want to say, realtors that were helping facilitate the quick sale and kind of fraudulent money laundering through, transactions 2 or 3 in a day. So I just want to be intentional that doesn't protect criminal organizations' financial organ racketeering of sorts.
Yeah, that's a really good point, Representative, because it's been so long since I worked on that language that it may be too, the exception may be too specific, in the sense that you could have someone you describe that actually isn't participating in the management, but is fully participating or knowledgeable of the illegal conduct. So I might want to stew on some new words in lines 10 and 11 on page 14. And I'll think about that. Because those are the words we have currently in our meth lab cleanup statutes, but this is different. Generally, meth labs weren't lucrative for people. They usually caught fire and blew up, whereas this can be really lucrative for people. So I need to think about that. I need to think about it, though, in the context of a banker, though. We'd still need to protect the bankers, otherwise they'll come out and they'll just kill this bill, or work to kill this bill. So let me stew on that language. I think you got a real valid point there.
So I guess what I'm hearing, Rob, is you're going to ponder this as to maybe an additional language to put in, not taking out what you have now, to maintain the current protections that are provided for the banking financial institutions as we see it being applied in meth lab areas.
Yeah, in essence, not protect security interest holders that are involved. Right. If they're involved in this conduct, then they shouldn't be protected, and that's a valid point. And the way I crafted it way back in the day for meth labs, I wasn't thinking about the lucrative nature of how you could be involved in a number of different ways, because it's a whole different deal here. So I will stew on that. The other thing I'll just mention is I didn't think to draft the MISTO that Josh mentioned. I'm certainly happy to craft that up for people to look at our next meeting if people want to look at it.
All right. Let's see, Sergeant Bechtel, I think you're up.
Thank you, Chair Brzezinski. I just wanted to kind of give some past experience with drug lab cleanup. I've been a member of our drug lab team since 2014, and I was even in charge of it for a period of time. One of the longest, most drawn out civil processes and deposition after deposition that I've ever been involved in as a police officer revolves around an innocent ownership claim on a renter's poly drug lab. And so I guess I would just want to, when we look at this, we need to be real specific about what we're cleaning up, the culpability of the property owner. Just to give an example that might be food for thought as we go forward with this, we had actually a DEA agent that owned a rental property. Unbeknownst to him, the renters started a poly drug lab. It definitely fit the definition of drug lab, so there was a reason to post it for cleanup at the time. But as lab results came back, there were no precursor chemicals. So the state caused a huge financial burden and loss to the innocent owner. And because there were no precursor chemicals, but it did fit the drug lab statute, there was a question that had to be litigated. So I guess what I'm cautioning here is the culpability of a property owner and the what we're cleaning up and what triggers that cleanup has to be super well defined, or it's going to put sheriffs, counties, and everyone in a not only a financial situation, but it was an extreme amount of manpower and time off the street for me to be in those depositions.
Thank you for the insight. All right, I do not see anyone else having their hands up for comments. I'm going to give it a moment. We are going to go back, and Aaron, we are going to give you an opportunity to make comments on sections 1 through 5, but I just want to go ahead and wrap up the comments on the new sections. Anyone else have any other things they would like to share at this time? All right, let's go ahead and jump back. Aaron, it sounds like maybe you've got your audio working.
How's this sound?
It sounds like we can hear you. That's an affirmative.
Awesome. That's great. Thank you. Well, I'm sorry to be late to the party in more ways than one. Aaron Pettigrew, Oregon Judicial Department. On section 1, we've been looking, and I think Heidi previewed this in the last meeting, but I just wanted to loop back on this. We've been looking at how we can streamline and utilize the senior judges that we have serving OJD to the greatest extent possible. And that includes removing some of the administrative barriers that stand in the way of allowing them to do work, including after-hour warrant service. So we've also been examining the same statute in section 1 for a possible change and a slight technical fix for next session. And so really glad that we're looking at this at the same time so that we can collaborate on what that solution might look like. And so first, in response to the draft that Rob prepared, I think any move to expand the ability of our circuit court judges to do that kind of interjurisdictional work would be welcome by OJD. The language itself, the interrelated conduct, that was flagged by some of our attorneys as potentially being somewhat vague and might generate some litigation around that. For us, that's not a cause to oppose, but we just wanted to make sure that was flagged so that folks could think about whether either that could be tightened up or utilize other language that's in other statutes, or maybe make sure to create some legislative history on intent so that can help guide our courts if they're reviewing challenges to those search warrants. The other piece that we wanted to talk about, and then we just had a drafting suggestion that perhaps that new section could live in subsection 2 of the existing statute, since that is the section that sort of expands upon the general prohibitions that exist in section 1. So that's just sort of an organizational suggestion. not really substantive one way or the other. As far as what OJD is considering, we just wanted to briefly preview this for folks, and we're happy to send some suggested language out to the group, looking for some sort of community feedback on whether we could explore looking at subsection 3 to allow for, subject to presiding judge approval, not only just circuit court judges who are appointed pro tem, but also our senior judges who are appointed and approved by the presiding judge of their district to do those interjurisdictional search warrants as allowed in subsection 3. So I know no one has language in front of them, but that's just another thing that we're thinking about. And also thinking forward to avoiding conflict amendments, want to make sure that we're all working together on that piece. So I'd be curious to know from this group whether expanding the availability of our senior judges that have been approved by presiding judges to do search warrants, particularly after hours, whether you think that would be welcome or helpful as a starting point, and whether you're finding that after hours search warrants that require, say, an affidavit of unavailability is a procedural barrier. Because that's something that we're trying to find out on our end, but I know there's a lot of folks here that could hopefully help us answer that question.
All right, so Aaron, let me just get clarification. When you refer to subsection 3, I'm assuming you're referring to your section 1, subsection 3 on page 2, top of it?
Yes, Senator, that's what she's referring to.
Yeah, I just want to make sure we have that clear for the record since there are multiple subsections.
Thank you, Senator.
All right, so that's fine. And then I guess the other thing, Aaron, that I'd like to know, I know that this was something that you ran past my office as to where my perspective was, and I said, please go ahead and move it forward. Can you tell us where you're at in the process of working with the Chief Justice and getting comments and approval for those concepts to move forward?
Thank you. Yes. So we will have the next couple of weeks to get our LC in order because we have gotten our omnibus bill back. So we're looking to add that to our big bill, our big OJD bill, so to speak, within the next couple of weeks. So if this is something that folks think would be helpful, in the abstract, I'd be glad to send around the draft that we have prepared, and your feedback will help us give the chief some direction on whether this is something that at least this community thinks would be helpful and might lower some administrative barriers in getting after-hours search warrants or multi-jurisdictional search warrants. So to answer your question, Senator, I think the chief is really eager to hear where folks are landing on this idea and whether it's helpful. And with that information, we can do the final decision-making with her.
Okay, so I saw a number of thumbs up, and that tells
Great.
me that yes, please send the material out. And I do want to say honor and respect on one of the parts of what judicial wants to make certain is that the presiding judge in each of the districts maintains, call it that, local control as to what they authorize for the individuals, either pro tems or senior judges, to be able to do within their judicial districts. And so I think that's something that I thought in the draft was written appropriately. But for those who have not seen that draft language when it sends it, I think, Aaron, the easiest thing I'm going to ask is for you to get it to either Tisha or to Michael, and then they can send it out to the whole group, and then we'll have a tracking on it.
Thank you. That would be great.
All right, other comments on, we'll just stick right now on section 1 through 5 based on what Erin suggested and things she wanted. Is there any other comments subcommittee members want to provide at this time? All right, I'm not seeing anyone. So I'm going to open this up at this point to any comments again on the presentation for today from committee members. Open up from section 1 through 15. Anything else that you would like to put on the table as to things that we should be moving forward? Really asking Rob to reflect on based on other comments we've heard today. Courtney, I see your hand up.
Yeah, I want to say, Rob, thanks so much for drafting this. I know you put a lot of effort into it, and I really appreciate you taking all the comments and dialogue that we've had over the last couple months and putting it into the text. And then I also just wanted to echo Tyler's comment about the scope of the cleanup and make sure that the language is very clear what that scope is. So thank you both. And thank you, Chair Brzezinski.
You bet. Thank you. So, folks, I'm just going to jump right in here. We're at 9:55, and I'm going to jump into the next steps based on not hearing any other additional comments. And I think you know what our next steps are, is basically Rob's back to the drawing board as to supplemental, not anything starting from scratch, to fine tune and tinker with it. I know a number of the members are going to get more additional information to him. I think that's very important that you get that to him as quickly as you can. Of course, as you know, well, let me just as a reminder, if you don't know, we do have our deadline for bill submissions this coming Friday, the 23rd, so a week from today. Clearly, we will have a draft going in. Yes, we can modify and improve, but this is a good time for us to be at least getting the framework as best we can. So with that, I'm going to, Courtney, your hand is still up, I think, from previously. I've got Representative Morgan's hand up, so why don't we go with Rep. Morgan, and then we'll see if we can buy back about 30 minutes of your time to do other things. Rep. Morgan.
Thanks, Senator. And if we do have time, I'd love to see the 3 minutes of the Sheriff Sickler video.
Oh, yes, thank you. Yes.
But I also, Courtney, yesterday in the cannabinoids meeting, you reminded me that something was for the law enforcement meeting, and now I'm forgetting what that is, as far as what that topic was. So I was going to try to have Courtney pick my brain, or remind me rather.
Yeah, you had just mentioned that a lot of this started with the illegal grows, and we were talking about the overall concepts for House Bill 3000 and what we're doing on the ground. And then I was just mentioning that we were working on the search warrant authorization expansions with the law enforcement subcommittee.
Okay, so nothing more that needs to be added to this bill. The only other thing I would ask Rob, with the changes that we did in House Bill 3000, and the changes recommended in the draft. This did start initially with my sheriff coming to me and saying people are hiding behind a hemp license. And so under the guise of a hemp license, they can grow whatever they want. I mean, we've since seen such a huge amount of drug trafficking organizations not even being licensed at all. But I guess I know they created a misdemeanor level of manufacturing under the hemp license kind of thing. And so I just want to make sure, are we looking at the full scope of which supersedes? If this new language says they have people that they're trafficking on, or they're creating environmental issues, but they have a hemp license, are they limited to that $10,000 fine? Are they limited to that misdemeanor charge because of what's precedence there with the license? Or does this supersede because it's a higher level? So I just want to throw that out there for you to ruminate on as well, in light of what we passed last year and how this would impact that, is just looking at the cohesiveness of what's newly being recommended and what's already in place.
All right, thanks for the comment. I mean, my perspective, this would supersede and override, but it may be worth putting in a statement that somehow you don't get additional protection just because you have a hemp license. I mean, to me, illegal is illegal. And as long as that is shown that that's happening, then it should be the primary. I mean, that should be the end of the conversation from my perspective. So other quick comments on that, and then I apologize, I did not write down about the video. And yes, we do have the time, and I would think it would be very appropriate for us to see it.
Okay,
Tisha, you're coming on. Go ahead.
Yeah, he sent the video to me, and so what I'll do is I'll just share my screen, and then I can forward the link around to people as well.
And I
All
think
right, that
as
ahead.
we if we view this, I think it just kind of reinforces the kind of the magnitude of some of these locations and how much labor goes into trying to clean them up and to deal with them. And so the importance of making some legislative changes to help us, I think, is really important. And this video kind of highlights some of that.
Okay,
Right.
can everybody see this Facebook screen, blank screen for now?
Yes.
Maybe hit the double arrows just in the black bar at the bottom and it'll make it full screen next to this sound.
Sheriff Sickler, sorry, I missed the beginning. What's the context of the video? Is this the most recent raids?
It's one of them, and there is sound to this video, so I don't know if it's clicked on Patricia on your screen or not, but yeah, we did this last week, and you can just see the massive amounts of product they have at the location, to where we emptied bags like that for hours, and then we got a tractor to push them and empty them, and that was all product that had been saved over a couple years, all unlicensed, no licensing whatsoever. But just a massive, I mean, we had probably 40 or 50 people out working at this site, and there's a lot of product and plants.
Sheriff, I got a question. Are those your machines, or is that county roads, or how are you commandeering those?
Yeah, that one was actually on site, and we had some people that were experienced operators and ended up using it just because of how massive this was. So it was actually two of the little tractors are ours, the little ones that you saw running over, and you'll see something here. We rented a piece of equipment. That one was rented. And then the little Kubota that you saw in the beginning part is something that we bought, I think, a couple years ago, for grows. And this was obviously you have to go kind of row by row. And I know you know what that means, but so it's better than pulling it by hand or kind of with a weed whacker, but it's certainly not as effective as being able to push it into a pile with like a D6. And you can just see the scope, how much plastic and mess this site is.
Did you guys count how many Costco containers you had back there? I mean, I call them the Costco containers, but
yeah, we didn't count. It was too much to count. I mean, those bags were stacked 8 feet tall, and that shop was probably 50 by 100 or something, and it was completely almost full with processed product, other than the area where you saw the tents and the kind of the living area next to all that.
All right, well, that's very eye-opening as to seeing the magnitude of what you're dealing with in that particular one. And it sounds like many of the sites that you are coming across have similar situations.
Yeah, that was I think a bit bigger than usual. It had been operating for a couple of years, obviously, and we just didn't have the resources to get to it. I think we had known about it for a year or so, but again, as we talked about, the importance of these grants for us to have ample staffing to address complaints in a timely manner. But yeah, this one had been unchecked for a couple of years, and certainly they had been saving their product in those bags. And some of it was obviously not great product any longer, but I'd hate to see that stuff go to market. You don't know how it was cultivated, what chemicals were used, and then the mold and other things on top of it, or provide a whole new or whole additional set of circumstances other than just the black market piece.
Right. Right. Other comments from committee members?
Chair, if I could comment really quick, this is Tyler Bechtel.
Go right ahead.
You know, unfortunately, what the sheriff just showed is more common than not. And the reason I asked about the equipment is because I would love to have those resources. We fix suspects' tractors to be able to use them so that we can leave that day and not pay for labor overnight. People twist ankles, blow out knees. We recently had an allergic reaction to something on plants. There's even just allergies. I can't function the next day when I get around all that pollen. The state police doesn't have the resources. We would have to pay wages, costs associated to ODOT to possibly borrow their equipment. It would have to go all the way to the top of my agency and across to the top of ODOT just to get a dump truck. We are fortunate that we've seized for forfeiture and later utilized some equipment, but now we've got to train cops on how to be equipment operators because of OSHA regulations. The cost is extreme. Those machines are not cheap, and I would love to have a couple parked out back, but even that presents problems because we don't have any room to store them.
Well, I mean, those are, I guess, insights of how can we move forward and address a lot of this. I mean, it does seem to me, I'm just going to use the term mutual aid agreements between agencies should be something that should be, I think, considered, and not something that has to be done on a piecemeal basis for each and every time you need a piece of equipment. I think the other concerns that you've raised as to having people properly trained as operators is essential, and I could see where you could have that financial cost of having borrow an employee from ODOT or whoever to operate that type of equipment that would be needed. So those are things I think that, again, we need to be focusing on as to what is the most efficiency. And maybe this is part of a strike team approach where we would actually have the equipment that's necessary to carry out these type of endeavors that would actually be able to be brought in under the purview of having that strike team available for local use, meaning through the counties or something to that effect. So we can brainstorm more and more on that. But I hope that everyone that had the opportunity to see this video, see the magnitude, even though this may be one of the larger ones, you can see even if it was half its size, it's still big and a lot of stuff to deal with. And looking at on the environmental side, how much of plastic waste, etc., has to be dealt with, or you're just going to cause even more issues for others that are unintended victims downstream from those type of operations. Other comments?
Yeah, just in that particular site where there were about 20 laborers that were interviewed by Homeland Security to try to narrow down some of the labor trafficking piece and whatnot as well. So it was one of those sites where it pretty much kind of encompasses all the things we've been talking about at one place. And I do think Sergeant Bechtel's right. The statute, the legislation that is being proposed, having the ability to contract or use people who are trained quickly and having the funding to do that is important. Strike force idea is interesting as well, but I think across the state and how many of these operations probably go on a weekly basis, like for our team to try to schedule, a tractor operator and then say, oh, they're backed up for 3 or 4 weeks because they're working in Lynn County or Lane County or Douglas County or wherever. I think each county being self-sufficient is really important, and or at least regionally. We share a lot of stuff with Josephine County. They helped us on this particular site. So did the state police, because it was, I think there was probably 50 or 60 uniformed or sworn personnel working up there. But they're pretty overwhelming if you don't have that kind of resource.
Right. Understand. All right. Any other comments? Well, unless there's other quote unquote statements or comments for the good of the order, I think we are, Tricia, help me out here. I believe we're scheduling meetings in October. And I'm not sure if this for our subcommittee, our work here, or if we're talking about the larger one that we've kind of penciled in for mid-October.
Yeah, the main task force has a couple of meetings already scheduled for October. Those should be on all of your calendars, and we're trying to squeeze one in there that also allows for a presentation from the Department of Justice Environmental Crimes team to provide some information to the subcommittee. And we're looking at October 20th at this point, but we'll finalize that and get that out to you as soon as possible so we can get it on your calendars. And also we're looking at the same time at having an update from the Criminal Justice Commission on their seizure reporting analysis that they've been doing.
All right, so that's a preview. Hopefully October 20th will work for most. We've been floating that date around, and it looks like it's a pretty good date for a good number of people. So if you could pencil that in, and as Trish said, we'll get word out to you. But it will help us getting these other couple of presentations to make certain that we're getting as much information as we want and need as we move forward this legislation.
Patricia, do you have what time on the 20th?
No, we have not scheduled a time yet. If you want to email me, if anybody has time conflicts, it would be in the morning. So feel free to email me.
Okay, thank you.
All right, well, I'm going to say thanks for everyone for participating today. I think we covered a lot of ground. Rob, as I said earlier, thank you very much. You are batting over 1,000. And so really, really happy that we have you to help assist us through this process and making it a lot more streamlined. So with that, unless someone else has any other closing comments, I want to thank everyone. I hope everyone's safe and be well. And hopefully we won't see a repeat. I'm not sure what's happening in the Southern Oregon part. I will make note that I was briefed, and I think many people have heard there's a possibility this weekend, at least in the central part of the Cascades, to have an east wind. So I'm hoping the modeling is wrong and that doesn't occur, so we won't see a repeat of 2020, but please be safe and be aware that we could have a lot of situations coming over the weekend that our neighbors are going to need help. So with that, thank you and be well.